today we are going to discuss about the scope of discharge in the Criminal Procedure Code. I was wondering as why Mr. N.Manoharan has chosen this topic for our today's discussion. In fact, the scope of discharge is a very apt one in the course of the trial, but many of us have completely forgotten, and in many occasions the discharge petitions are being filed only for the purpose of avoiding the particular trial judge or to prolong the matter for some time. But my view is that the scope of discharge is wider than the power of the High Court under 482. Therefore, at least we can invoke the powers of discharge hereafter by taking note of some of the judgments which I am going to place it for you for consideration in your future practice. There are three provisions available for discharge. First, 227, section 227 Cr.P.C relating to the discharge in respect of the sessions trial. In fact, 227 was not there before the Act 1974. In the old code, there was no scope for discharge in respect of sessions trial was concerned. So only this provision was inserted by way of 1974 74 Act. Then second provision is 239. The scope of discharge in respect of the cases instituted on a police report before the magistrate, which is conducted as a warrant trial. So warrant trial is being conducted on the police report, in which we can invoke section 239. The third provision is section 245 Cr.P.C. This is relating to the trial of cases where otherwise than on a police report, that is a private complaint. Only these three provisions are available in the code for the purpose of filing discharge applications. Before going into the discussion, let me explain what are all the similarities between the three provisions. In my view, except the phraseology, the words used in three sections, difference in words used in the three sections, in effect, all the three provisions are one and the same. Let me read the main limp of the provision for our easy reference. Section 227 Cr.P.C relating to the sessions case reads that the court considers that there is not sufficient ground for proceeding against the accused. The important word here is not sufficient ground for proceeding against. Similarly, section 239 relating to the warrant trial before a magistrate is concerned, the words used in section 239 is the magistrate considers the charge against the accused to be groundless. Charge against the accused to be groundless. Earlier, 227 says that not sufficient ground to proceed. Here, 239 says groundless. The third provision, section 245(1), says that the magistrate considers for the reasons to be recorded that no case against the accused has been made out, which, if unrebutted, would warrant his conviction. So the evidence as it is goes unrebutted would warrant conviction. Only in those cases the court can enter. These are the three different wordings used in 227, 239, and 245. But except the different variations in the phraseology, in effect, all the three provisions are one and the same. In fact, this came up for consideration before the Honorable Supreme Court in 1986 to SEC. 1986 to SEC 716. 1986 to SEC 716. The famous case R.S. Nayak versus A.R. Andule. In this case, the Honorable Supreme Court judgment rendered by Mr. Justice P.N. Bhagavati held that these three provisions in effect are one and the same. The purpose of this provision is only to discharge. Therefore, there is no, even though the code has used different wordings, we have to take into consideration that in effect all the three provisions points out only discharge. The same view has been reiterated by the Honorable Supreme Court in 2002, 1 SEC, page number 465. 2002, 1 SEC, page number 465. Then let us see when the discharge provisions, discharge petitions will lie. As far as 227 relating to sessions trial and 239 relating to warrant trial before a magistrate are concerned, discharge petition will lie before the charges are being framed. So after 209, after 207 copies, and before after committal, if it is before a warrant trial, there won't be any committal. The case will be pending before the magistrate. So after furnishing of the 173 copies police report, before the matter is being posted for framing of charges, the accused is entitled to file an application discharge will not lie. So the discharge application in respect of 227 and 230 framing of the charges. This position of law has been well laid by the Honorable Supreme Court in 1979. 1979 2 SEC. 1979 2 SEC 179. 2004 6 SEC. 2004 6 SEC 522. Then the third judgment 2008 10 SEC. 2008 10 SEC 109. So discharge petition to be filed before framing of the charges. As far as the third category under 245 is concerned, the complaint the cases instituted otherwise than on a police report, that means private complaints are concerned, after 204 after recording of taking the complaint on file, the court will issue process to the accused under 204. So after entering appearance by the accused, the court has to proceed to examine the prosecution complainant and his witnesses. So only after recording his statement before the court, before proceeding to frame the charges, the court is entitled to discharge under section 245. So please read section 244. 244 clearly says that after issuance of summons, after entering the appearance of the accused, before proceeding to frame the charges, the court is entitled to discharge the accused. Here, the court is entitled to record evidence before framing the charges. You know well, there are at least in 3 occasions, the evidence of the complainant is being recorded for the purpose of the trial under section 244 and 245. So first, before taking cognizance under 201, 202, then second under 244, then after framing of charges, there are 3 occasions the complainant has to let in evidence. There are another category, discharge, whether discharge application is maintainable in a summons case. Prior to 2004, that is the judgment of the Honorable Supreme Court in Adalat Prasad, reported in 2004 7 SEC, 2004 7 SEC 338. Discharge petitions were being entertained even in summons cases. But the Honorable Supreme Court in first time in 2004 7 SEC 338 held that in respect of summons case is concerned, once the court has taken the cognizance and issued a process, the question of recalling the process doesn't arise, because the court has clearly held that there is no provision for framing of charges in the summons case. Therefore, the question of discharge will not lie. So earlier we were doing it pursuant to K.M. Matthew case in 1992, but that judgment has been expressly distinguished and held that no such discharge application is being entertained under in respect of summons case is concerned. The very same view reported in 2004 7 SEC 338 in Adalat Prasad has been followed by Madras High Court in 2005 Criminal Law Journal 1820, 2005 Criminal Law Journal 1820, and another judgment in the same book, 2005 Criminal Law Journal 1997, Allahabad High Court. But little deviation has been made by the Honorable Supreme Court subsequently in 2012, 5 SEC 424. 2012, 5 SEC 424. Because the Supreme Court has made an attempt to deviate from the earlier view in 2004, 7 SEC, holding that even in a case of someone, even in a case relating to someone's case, if absolutely there is no material on record, there is nothing wrong in dropping the proceedings. This was the view taken by the Honorable Supreme Court in 2012, 5 SEC 424. Before going into the circumstances in which discharge application is maintainable, let us consider how the provisions are being worded under section 227. Let us read 227. 227 reads that if upon consideration of the record of the case and the documents submitted therewith, and after hearing the submissions of the accused and the prosecution in this behalf, the judge considers that there is not sufficient ground for proceeding against the accused, he shall discharge the accused and record his reasons for doing so. So there are 4 essential ingredients so far as discharge is concerned. Firstly, the court has to consider the record of the case and the documents submitted therewith. The record of the case and documents submitted therewith are nothing but a police report and the documents filed along with the police report under section 173 subclass 2 Cr.P.C. So the first aspect is concerned, the court is bound to confine itself only to the records available on records of the case and the documents filed along with the 173.2. Secondly, after hearing the accused and the prosecution, so the court is bound to hear the accused and the prosecution. The hearing is concerned, it is even though none of these three provisions says that an application has to be expressly filed by the accused for the purpose of discharge. Abundant caution, it is prudent on our part to file an application to discharge, because only then the court will be in a better position to appreciate the points focused by the defense counsel, accused counsel in the discharge application. In the case, suppose in case the petitions were dismissed, in the event of filing revision before the Sessions Court or High Court, we have to canvass our points only when it has been specifically raised in the discharge application. Therefore, the prudent course would be to file an application expressly instead of orally request to the court to discharge. So the hearing of the accused and the prosecutor is mandatory under the section 227. The third, the judge considered that there is no sufficient ground. The court has to come to a conclusion that absolutely there is no ground to proceed further. Ground means not ground, that is, what is the term ground has been discussed by the Honorable Supreme Court in 1989. 1 SEC 715. 1989 1 SEC 715. The word ground in 227 does not mean the ground for conviction. Does not mean the ground for conviction, but a ground for putting the accused on trial. Ground for putting the accused on trial. There must be a prima facie case for the purpose of proceeding against. The ground which is available need not show that there are enough materials to for conviction. If there are enough material for prima facie coming to a conclusion, that is enough. That was the law laid down by the Supreme Court in 1989. Similarly, 1987 3 crimes. 1987 3 crimes 842. Groundless. That is relating to 239. Groundless means without any basis or foundation. Without any basis or foundation. So the fourth limb of section 227 is that the court has to record reasons for doing so. For either for allowing the application or for dismissing the application, court has to give express reasons in the order. But I have seen in my experience, many of the orders says that there are in the last on the penultimate paragraph, the orders would indicate that the veracity or merits and demerits of the statements cannot be gone into at this stage. Therefore, it could be gone into only at the time of trial. Therefore, discharge applications dismissed. So these are all the ready-made reasons are being given for dismissing the application. My view is that probably these reasons are being given only on the presumption that the scope of discharge is very, very molecular. Therefore, the court is not supposed to go into the merits and demerits or shift or weigh the materials available in the form of final report. Probably that could have prompted the courts to dismiss the application in a bold and cryptic order. But provision itself indicates that either for allowing or dismissing, court has to give reasons, because this order is also subject to judicial review. Therefore, always the court has to indicate reasons for dismissing or allowing application. Similarly, if you read section 239, which is meant for discharge in respect of police case is concerned, similar wordings are there, but similar wordings but differently worded. If upon considering the police report, there the provision reads that record of the case and documents. Here the wordings are upon considering the police report and the documents sent with it under 173 and making such examination if any. So almost similar wordings are there in 239 also. And here again the court says that if any of the accused as the magistrate thinks necessary and after giving the prosecution and the accused an opportunity of being heard. So here again the accused and the prosecution have to be heard. Then the court considers the charge against the accused to be groundless. So the consideration of the court that the charges against the accused are groundless is very, very vital for the purpose of deciding the discharge application. So the court should come to a conclusion that the materials produced by the prosecution are totally groundless. Then the court is entitled to discharge by giving reasons for doing so. That is also there in 239. Similarly, 245 says that if upon taking all the evidence referred under 244, the magistrate considers for the reason so recorded that no case against the accused has been made out of which, if unrebutted, would warrant his conviction, the magistrate shall discharge him. So the evidence which was recorded under section 254 goes unrebutted, then would warrant, even assuming that the entire evidence recorded under 244, no case is made out, even if it goes unrebutted, then in case the court is entitled to discharge. So taking the entire evidence recorded under 244 makes up no offense except some vague allegations. Then it is not enough for the purpose of proceeding further. Therefore, the court is entitled to discharge the accused. Therefore, all the three provisions clearly says that the court is entitled to take note of the records of the case and the documents filed in the form of police report under section 173 clause 2. So neither final report nor charge sheet are used in the code. The code only says police report, but we are commonly saying that a police report or a final report. But the code only refers about the police report, not final report or charge sheet. Be that as it makes no difference. Then we have seen that the provisions prima facie indicate that only the police report could be gone into for the purpose of deciding the discharge application. In fact, a classic case rendered by the Patna High Court in 2006, Criminal Law Journal 1441, 2006 Criminal Law Journal 2441. Let me read the operative portion of the order. The Patna High Court has held that if the statement as recorded by the police, under 161 Cr.P.C is in respect of accused are taken to be correct in its entirety. In other words, if they were to be made as it is in the course of the deposition, then whether that would be sufficient to uphold the charge. In effect, the Honorable High Court has held that even assuming that the entire 161 statement, 161 subclass 3 statement is going to be deposed as evidence before the court, then no case is made out, then that can be taken into account for the purpose of discharging. Because normally 161 statement is being used only for corroborative version. Now the Supreme Court very recently in 2021 held that we cannot refer even 161 statement because it has no probative value. That's what the Supreme Court has observed. I don't know how court can go into if the 161 statement is excluded. If 161 statement is excluded, there will be no other material available on record for the purpose of passing or even discharge. So we can't reject the 161 statement solely on the ground that is inadmissible. No doubt it is inadmissible, but it can be used for the purpose of corroboration in the course of the trial. Contradiction in the course of the trial. Sorry, I said corroboration. It is not corroboration. Contradiction in the course of the trial. But at the time of deciding discharge application or quash petition, this is the only piece of evidence available before the court for the purpose of deciding the fate of the matter. Therefore, with due respect, if 161 is excluded from the purview, then neither discharge nor quash petition could be decided on merits. So this is the law laid down by the 2006 Criminal Law Journal 4441. The judgment of Patna High Court we have discussed. Then next, whether from reading of these three provisions, prima facie would ipso facto indicate that only the police report can be gone into. Other than the police report, whether other materials produced by the document could be gone into. Supreme Court said yes in 1996, 9 SEC, 1996, 9 SEC 722. 1996, 9 SEC 766. Two judges bench of the Honorable Supreme Court in Sadish Megra case, Supreme Court has held that if the documents, even the defense document could be gone into, because the wordings in 230, 227 and 239 says that the documents submitted therewith after hearing the submission of the accused. So the hearing of the accused must be effective hearing, not mere formal hearing. Therefore, the Supreme Court has held that even the defense document can be gone into, can be taken into account for the purpose of discharge. This view was not, there was a contra view was taken by the Honorable Supreme Court in 1999 SEC Criminal 373, equivalent to 2008 14 SEC. 99 judgment was reported in 2008. 2008 14 SEC 13. 2008 14 SEC 13. In SEC, it was reported later. SEC Criminal, it was reported in 1919 itself. In this judgment, the Supreme Court did not agree with the law laid down in Sadish Megra, and the Supreme Court has held that the wordings used says only the records of the case and documents filed, which is confined only to the police report and not beyond that. This was the view taken. Therefore, when the matter came up in state of Orissa versus Debendranath Padi, reported in 2003, 2 SEC 711, 2003, 2 SEC 711. This is the reference order passed by the Honorable Supreme Court. So in view of the conflict in views in earlier two judgments, the Honorable Supreme Court has passed a reference order in 2003, 2 SEC 711, and the matter has been referred to a larger bench of 3 honorable judges of the Honorable Supreme Court decided the position of law in 2005, 1 SEC 568, 2005, 1 SEC 568, 3 judges bench. So the reference order reported in 2003, 2 SEC 711, the final judgment reported in 2005, 1 SEC 568. The Supreme Court in its categorically held that the defense document, irrespective of the sterling qualities, it cannot be looked into for the purpose of discharge, because the scope of discharge is only to ascertain whether the case is made out to proceed further on the basis of the records available, the records produced by the prosecution, and neither the defense plea or the defense document could be gone into at the stage of discharge was the view taken by the Honorable Supreme Court. The same view was followed in 2008 10 SEC 109, 2008 10 SEC 109, 2008 5 SEC 113, 2008 5 SEC 113. These 3 judgments are only in line with Debendranath Padi. But yet again, 2 judges bench of the Honorable Supreme Court in 2008 14 SEC page 1 took a view that the view taken by 3 judges bench in Debendranath Padi may not apply in all the cases, and we have to take bench of the Honorable Supreme Court reported in 2012. 12 SEC 406. 12 SEC 406. Let me read one line from the judgment as to why the Supreme Court has taken deviation from the earlier 3 judges bench. Para 16, Supreme Court has held like this. In a rare case, it is permissible to consider the defense evidence if such material convincingly establishes that the whole prosecution version is totally absurd, preposterous, and concocted. Let me read again the quote from para 16. In a rare case, it is permissible to consider the defense evidence if such material convincingly establishes that the whole prosecution version is totally absurd, preposterous, and concocted. So this is the view taken by the Honorable Supreme Court. Even though this view is plausible, but we are not supposed to deviate from the 3 judges bench judgment of the Honorable Supreme Court reported in 2005 1 SEC 468. But let me place one example for kindling the mind of our young people here. A person has been charge sheeted for under section 25 of the Arms Act, saying that he was in possession of an unlicensed gun. This was the crux of the prosecution. But the accused suppose accused is having a license issued by the competent authority. Is he not entitled to file a discharge application before the court saying that no, the very crux of the charge is groundless because I am having a license? It can be done. Similarly, suppose a person has been charged for murder or attempt to murder, but at the same time he was confined at his prison, or he was confined at some other place with the relevant materials. Then we can move the application. In fact, our senior advocate, Mr. B. Mohan, has filed an application in one murder case when prosecution case was that the accused in point blank shot the accused dead, shot the deceased dead. But he came to know that at the very same point of time, or 10 minutes or 15 minutes earlier, the accused was very much available at Tirupati. And his finger impression and this photographs and other identities were taken for his stay at Tirupati. But the occurrence took place nearly 200 meters, 300 kilometers away from the Tirupati. Then on that basis, an application was moved, and he had made an attempt even to summon those records from the Tirupati Devasthanam board for the purpose of proving the case. So these are all the classic cases where we have to entertain, but the law is very clear, but we can't go deviate. But this position of law has no application in so far as past petition filed before the High Court under 482. I don't find any deep difference between discharge and the past petition. But even past petition, the Madras courts have held that if a document is of unimpeachable sterling qualities, அதனுடைய நம்பகத்தன்மை யாரும் சந்தேகிக்க முடியாது அப்படிங்கிற ஒரு சூழ்நிலை இருக்கும் பட்சத்துல that can be looked into for the purpose of causing the accused. Take an example, some 138 cases, or even in a case relating to some prosecution has been launched against a company or a firm. Then one of the directors says that no, I was not there at the relevant point of time and I had resigned from or relieved from the said firm. That resignation would have been communicated to the register of firms. That Form A certificate is more than enough. It is a public document that is enough for the purpose of proving his absence at the in the day-to-day affairs. So these are all the documents can be looked into. But the Supreme Court in clear terms held that it can't be looked into in respect of discharge petition is concerned unless this view is overruled by the larger bench of the Supreme Court. We are bound to follow this decision is my view. Now there are another important decision of the Andhra Pradesh High Court. Full bench judgment of the Andhra Pradesh High Court is worth reading. AR 1980 Andhra Pradesh 219. AR 1980 Andhra Pradesh 219 full bench judgment. This is the case in which the Honorable Supreme full bench has laid down 5 principles under which the discharge can be filed. The list is not exhaustive, but let me have a glance perusal as the ground on which the full bench held that discharge application maintainable. The first ground, the evidence produced is not sufficient. The evidence produced is not sufficient. Suppose take an example, a simple money suit, complaint was given under 420. You know well, mere breach of trust is not enough. Criminal breach of trust means something more is needed. That means one should have an intention from the beginning of the transaction to cheat. So in the absence of any such essential ingredients for cheating, mere non-payment of money will not attract section 420. So in those cases, that is, the evidence is given an opinion, you cannot prosecute him for these offences. This was the view taken by the Honorable Supreme Court in 2012 9 SEC. Similarly, alibi is taken. That can't be a ground for a discharge, because Evidence Act clearly says that it has to be proved by the accused. In some cases, extraordinary cases we can do that, but alibi is concerned, it is a defense plea which has to be gone into in the course of the trial by producing evidence, and the burden has to be discharged by the accused. Similarly, 27 statement under 27. You know well that the confession statement is clearly barred under section. Confession given to the police by the accused is clearly barred under section 25. But limited purpose of disclosure statement, it can be looked into under section 27. Suppose, except the confession of the co-accused, no other evidence is available, the court is entitled to go into it. Unnecessarily, one need not be harassed, and there is no other corroboration available at the time of trial. Then no sanction, then limitation. Sometimes complaint is filed beyond the period prescribed under 268, but there was no explanation in the final report, or no application was filed to condone the delay by the police. Then court is entitled to. Regarding this, position of law has been well settled by the Supreme Court in Sarah Matthew in 2014 SEC. I don't remember the page. 2014 Sarah Matthew. Supreme Court has held that a crime never dies. Therefore, it is even the blatant complaint is maintained, provided they should meet the requirement under section 416 and 473. Similarly, civil dispute. Take an example: when a suit for partition is pending, one of the defendant alienated the property. Then criminal complaints are being given for cheating and forgery and fabrication against the defendant as well as the purchaser. Definitely no case is made out, because it will not attract the forgery or fabrication, merely because defendant has executed a document in favor of third party pending partition suit. No offense is made out. So it is a clear case of civil dispute. So in these are the cases in which the court can easily discharge. But it is on our part, burden is entirely upon the shoulders of the lawyers to read these decisions and convince the judge on the basis of the materials produced at the time of final report under 173(2). With this, I conclude myself. Thank you very much for giving a patient hearing. Thank you, sir.